Here this afternoon. I will say House Bill 430. I will tell the committee that there are some discussions going on about House Bill 430 that would result in, I think, fairly significant amendments to Delegate Wilkins' bill. There's still a lot of people talking about that. I know people have become very concerned. Just want people out there to understand that there's still work being done on that, and we're going to continue to work on House Bill 30, even despite the late hour in session. But we will not take that up today. House Bill 772, I'm going to hold to the end because I think the other ones are relatively straightforward, we hope, and we'll go through those. House Bill 755 is Delegate Cardin's bill. There's a motion for a favorable and a second. No, we don't have the Senate bill on there today. We will get to the Senate bill in the regular course that we're going to have with a bunch of other bills at a similar posture. Is there any discussion on the bill on 755? Seeing none. The Vice Chair? Yes. Yes. Munoz? Yes. Yes. Crutchfield? Yes. Yes. Cardin? Yes. Yes. Bartlett? Yes. Embry? Yes. Pasteur? Yes. Tolles? Yes. Schmidt is excused. All right, so no, Schmidt is not excused. Schmidt, you're here. I know, it's terrible. Schmidt is a yes. Simmons is excused. Boucher? Yes. Phillips? Yes. Tomlinson? Yes. Erican? Yes. Taylor? Yes. Simpson? Yes. Grammer? Yes. Young? Yes. Valentine? Yes. Conaway? Okay. Kaufman? Yes. Yes. And Williams? Yes. Yes. Conaway excused. All right. Favorable motion is adopted. Now, House Bill 1280. Just a little over the deadline, but here we are. There's a motion for a favorable. Are you sure about that? And a second? Really? Is that what we're doing here? I don't know. All right. I think this is her first bill in the committee. She's not paying any attention. She's talking to somebody else. She doesn't know what's going on. I could just sit here and talk all sorts of bad stuff about her bill and she wouldn't care. Okay. Oh, wow. Well, okay. All righty then. There's a motion and a second. Is there any discussion on this Delegate Taylor's first bill within the committee? It is. Nobody appears to have a question. Oh, I'm sorry, Delegate Tolles has a question now.
I'm so proud of you. Isn't that so? I got mushy.
So exhausting. All right, so let's, nobody else has any sentimental? Okay, fine. The Vice Chair? Yes. Munoz? Yes. Yes. Crutchfield? Yes. Yes. Cardin? Yes. Bartlett? Yes. Yes. Embry? Yes. Pasteur? Yes. Tolles? Yes. Schmidt? Yes. Boucher? Yes. Phillips? Yes. Tomlinson? Yes. Erican? Yes. Simpson? Yes. Grammer? Yes. Young? Yes. Valentine? Yes. Conaway? Yes. Kaufman? Yes. Yes. Williams? Yes. Taylor? Thank you. Favorable motion is, huh? I don't usually, I haven't done that, I think, for anybody else's first bills, and then I would, oh, this would be bad. Stop causing problems. Stop causing problems. I love you all, but oh my God. Okay, so, I can't, come on, who's your favorite? Who's your favorite? What was the best question ever? That's fantastic, yeah. Delegate Munoz would like me to say that I dislike all of you equally, which seems worse. But having said that, we won't say any of those things. Oh my God. Yeah, you were. Okay. House Bill 1300, the bill that the administration made me stand up on the floor to introduce everybody. There's a motion for a favorable in a second. Is there any discussion about House Bill 1300? Delegate Erican wants to explain. It basically gives the permission to DPSCS to be able to get background check information for people who want to be, DHR needs more information about whether they're going to be able to be foster parents or adopt kids or things like that. So it allows for those background checks to happen. And without that, that is a bad thing. So, yes. Any further questions? Seeing none. The Vice Chair? Yes. Munoz? Yes. Crutchfield? Yes. Cardin? Yes. Bartlett? Yes. Did you really say what? Yes. Bartlett? Yes. Embry? Yes. Pasteur? Yes. Tolles? Yes. Schmidt? Yes. Boucher? Yes. Phillips? Yes. Tomlinson? Yes. Erican? Yes. Taylor? Yes. Simpson? Yes. Grammer? Yes. Young? Yes. Valentine? Yes. Conaway? Yes. Kaufman? Yes. Williams? Motion's adopted. All right, now we're on the Attorney General's bill on House Bill 772. We heard this bill earlier in session. There is a Senate crossfile. We're not taking that up today, but there is a Senate crossfile as well that did pass out of the Judicial Proceedings Committee. I believe, are there amendments to there are amendments. Okay, so everyone should have the amendments. And Holly, can you tell us what those amendments do, please?
Yeah, so the amendments clarify the entities against whom the OAG may not bring a suit to include any unit of state or local government or against any employee or agent of any entity of a state or local government. The amendments also clarify the jurisdiction of the Commission and the OAG's authority. The amendment says that information obtained under the provisions of the bill may still be used in a criminal proceeding if the same information is obtained by a method independent of the subpoena under the provisions of the bill. And finally, they just clarify that the Commission and the OIG will make referrals and work together to eliminate duplicate efforts.
All right. There's a motion for the amendments. Is there a second? Motion for amendments and second. We're on the amendments. Is there any discussion about the amendments? Delegate Embry.
What the Senate passed.
Correct. This would effectively conform the House bill to the Senate bill as it passed the Senate. Delegate Erican.
So can somebody just walk me through a potential case now that we have those amendments? How does it change the process? What's the real life change going to feel like?
So I think the amendments are more clarifying than anything else. It clarified that the Attorney General can't bring one of these suits against an employee of state or local government. So it took them, or any unit of state and local government. And it's still, fundamentally, the core of the bill is it allows the Office of the Attorney General to do something similar to what the Department of Justice does, just on a state level when it comes to bringing civil actions related to civil rights issues. I think all the amendments do, again, I think are clarifying.
Okay.
Doesn't change the underlying theme of the bill.
Or the process. Okay.
Yeah.
All right. Thanks.
Okay, so on the amendments, all in favor of the amendments, raise your hands. Anybody opposed to the amendments? Eric can. The amendments are adopted. We're on the bill as amended. There's a motion for a favorable and a second. Now, discussion on the bill as amended. Is there any further? Delegate Cardin.
Thank you. Just a quick question. So the amendments that were adopted that were from, that also conform this to the Senate bill, that allays concerns of state agencies that we had heard in the past, right? So, okay, that's great.
Yes.
Thank you.
Is there further questions about the bill as amended? Delegate Schmidt.
I guess my question would be, and I don't know if you can answer this, Chair, what is the basis of this bill? I mean, I guess I understand like small business, large corporations, what? Just trying to understand it so I can understand how.
The idea is a business that acts in a way that violates a person's civil rights, they would be able to bring a civil claim to address those issues. Again, the Department of Justice has had this authority. This seeks to basically supplement that authority and allow the AG to be able to carry out those same suits as well. I believe the Vice Chair was giving one example earlier. Do you want to talk about some of the examples that you were looking at?
Sure. And this is just, I don't know why I know this, but dealing with country club policy and tax policy in Montgomery County, I learned some things. And this was an example from years ago, but we had a number of country clubs in Montgomery that were accused of different types of discrimination. Either racial minorities weren't being accepted, or women, in one instance, I think, weren't being allowed. And so there were accusations about this, but there was no way to verify what the membership lists were and who was actually applying and denied. And so there was a question about whether the Attorney General could issue subpoenas to get this sort of information for the purpose of ensuring compliance with this. Now, I can't remember what ended up happening with this particular scenario, but it sounds like the AG suggested there was a law change to specifically have to authorize subpoena power to even begin this question. But I think the way this one resolved, the entity decided to forego certain benefits in order to be able to continue discriminating and be able to have their way with what the membership lists were. But it was sort of a classic example of, it was unclear what the damages would have been, what lawyer is going to take this case, but you have a real sort of public policy question with a civil rights implication and very few mechanisms for anyone to try and enforce the law there. That's just one real world example I can recall from where multiples of these policy questions came into play about whether the Attorney General could bring an action. And this, maybe in this instance, it would have been not damages. It would have been injunctive action saying, no, you got to knock it off. You have to start accepting all manner of race and ethnicities that apply to be a member here. And again, what lawyer, it's not clear that a lawyer would have taken that case. And so I guess the bill contemplates both that there would be the power to investigate and the power to compel action. That's the only example I can think of that I encountered in the real world.
No, I appreciate it. Yeah, I guess my question, if a private, I get the explanation or the example with a private country club. I guess I'm more thinking of small business effect, and it doesn't truly outline, when it says recover certain investigation and litigation costs, it doesn't really say if there's a parameter around the amount. And I don't know how you put a dollar figure. I guess they have $1 per man hour or person hour to equate to that in the Attorney General's office. So I guess those are two things that I saw. But I appreciate you sharing an example. It reminds me of something that happened at, I guess, Augusta National down in Georgia 10, 15 years ago when they were in a similar situation. And I believe Condoleezza Rice was the first female member of that club. So I guess those are just some questions that I have around some parameters or understanding how they're going to bill certain businesses for any damages. So.
Yes, and I do apologize, Delegate Smith, I thought you were finished. But another example is, and we will just call this Johnny's Bookstore because as part of the arrangement, I'm not allowed to say who it was. But I went into Johnny's Bookstore and I couldn't get in one time because their store was not ADA compliant. And so I filed a complaint with the Justice Department Office of Civil Rights, and as a result, they had to engage in injunctive relief. So as I read the bill, if 20 people could not get into Johnny's Bookstore because it was not ADA compliant, then the Attorney General could file a lawsuit against Johnny's Bookstore on behalf of the 20 people with, in walkers or wheelchairs that couldn't get in. Is that accurate?
That would be, again, I believe that would be something covered. An ADA violation would be covered as a civil rights violation, and as is defined in the bill, an act of discrimination prohibited under the U.S. Constitution, Maryland Constitution, or state, or in that case, ADA, federal law. So that would be something that the Attorney General would be able to investigate and bring a civil charge,
Okay, thank you.
civil claim as well.
So hopefully that my example with Johnny's Bookstore does help you also, Delegate Schmidt.
All right, Delegate Young, then Delegate Erican.
Thank you, Mr. Chair. Just for context, an individual who is discriminated against can already go to the Maryland Commission on Civil Rights, or even if it's a local counterpart like the Office of Equity and Civil Rights in Baltimore City. So if you're discriminated against, you can already file a complaint. Your remedy in that complaint is usually some sort of monetary damage or punitive damage to the business, depending on what the commission decides to put down on that individual or rather business as a consequence of their discrimination. This bill would allow what Delegate Kaufman just mentioned, is that injunctive relief. Civil Rights Office can't issue an injunction, so only a judge can do that. The Civil Rights Office and that work is again, the adjudication of those cases is with a board that is normally appointed by the executive with the consent of whatever legislature. This, again, would be a court remedy of injunction, which has a little bit more weight. And again, I think that the Attorney General mentioned that you would see them bringing cases where there's more of a systemic issue, not in the one-offs. In the one-offs, the individual can go to the places I just told you. But in those systemic issues, you'll see the Attorney General want to step in.
I missed Delegate Tolles when I was calling one before Delegate Tolles and Delegate Eric.
No worries. I can come back. I'm trying to formulate. Thank you.
So this doesn't change the fact that you can still go through the federal system. They can still do the same. So is it potentially two cases then against the same person?
Ask the question again, please.
So right now, the federal government usually prosecutes these cases or whatever. Now, will they no longer do that, or will it just be the AG's office, or could they both do it to the same business for the same?
I think that you would have a situation similar to what you'd have if there was somebody who was charged on a criminal basis on a federal law that had a similar state charge. The federal charge would trump, and they would be able to take
Okay.
jurisdiction.
So this is,
I don't foresee, and I am going to take a look at the Attorney General. Attorney General staff. I don't foresee where they would be getting sued by both the federal government and by the Attorney General.
Okay.
It would be one or the other.
so would it like a case where the Fed said, we're not gonna pursue this, and then the AG's office can come in and pursue it even if the Fed didn't feel like there was enough evidence?
If the Attorney General decided they wanted to proceed, they could. Yes.
Okay, thanks.
Now, Delegate Tolles.
Thank you so much. I just want to try to remember. I'm looking through the committee the floor system. Is this where the State's Attorneys Association had kind of the angst where they wanted to, they felt like that some authority would be taken from them?
No, that was in a couple other bills. The pattern and practice bill at 771 is not before us right now, and there's another bill regarding the independent investigation of police officers.
Okay, because I'm looking at, and maybe it's just an error.
The issue that they raised is if the Attorney General should decide to raise a civil rights violation against an individual public employee of any kind, including a state's attorney, their concern was, one, well, they're supposed to be defended by the Attorney General, so how does that work? If the AG is if they're operating under the color of their office, how does that work? I think that's addressed in the amendments where it clearly says that they cannot sue an employee of effectively employee of a public agency.
Okay.
So it addresses that.
Okay, I'm looking at some testimony. I think somebody submitted something for 771 to 772. Got me a little confused. So, okay, I'm good. Thank you.
All right. Delegate Young, then I'll go to Delegate Phillips.
Delegate Toles, that's exactly what I wanted to mention. Is if you look at, I think it's 771, it's the exact same testimony, and I think I questioned that during the hearing because both testimonies were the exact same with just a number change, and I was questioning why they didn't just copied and pasted and didn't have one that was more specific to this bill. And I think I questioned Kroll and saying that I didn't think they understood based on that testimony what this bill did.
I just wanted to bring clarification on one thing, because this is my recollection, one of the reasons why the Attorney General said that they wanted to add this as part of their role and responsibility is because the feds don't have this, they may not deal with certain issues here in the state of Maryland, and they may not have the same level of resources focused on this. And so it would bring an added local perspective to addressing some of these issues. So I just wanted to make that comment. And I thought that was part of the difference between what the feds do today and what he had proposed.
Further questions? All right, we are on the bill as amended. I believe there was a motion and a second. Delegate Valentine, though.
And that will tie into the resources, because this will obviously bring on quite a bit of more work. And I look at the fiscal note and I see a substantial fiscal note based on this. So they really don't have the resources for this. They're going to need more resources for this. So that's one concern. And the Maryland Fed concern is the second that was raised already about, well, we don't have enough here, but maybe we'll have enough there. So those are just two of the concerns that I had. And in the letter from the Chamber of Commerce, where it talks about I believe it's the actual wording is reimbursed for the expenses, which Delegate Schmidt brought on. Is there any other type of situation on the civil side that I'm not familiar with where a government entity is reimbursed for investigations they initiate? That's the concern I have.
I was trying to think of something really quickly, but I know, well, I mean, that's not really into your turn.
That with the tobacco restitution money, this was an investigation that was, or a procedure that was started by AGs across the country. And then the money, part of the restitution fund was used to reimburse the state for the legal costs, or for the private entities that assisted the state in
the tobacco settlement years ago. Is that the one you're?
I mean, it's still happening.
Yeah,
that's an example.
That particular line, I just thought that because I've never seen something like that, and that would be an example that I wasn't familiar with that.
I wouldn't be surprised if we had the same situation with the lead paint litigation from even longer ago, but that's before my time.
All right. Any further questions or statements? All right. Delegate Schmidt?
I mean, I know a lot of this is coming at us today. I mean, is there a way to vote on this tomorrow?
Look, if you would like to come back and vote on it tomorrow, that's fine. I can hear the concern that some people have.
Yeah, okay.
And so we can come back tomorrow and do this. We may also be able to take up a couple other minor bills. So what we'll do is this: we will come right after the floor session tomorrow, and we'll have a voting session in the right after that. So I would anticipate probably around 11:45 or so we'll have a voting session. And we can take this up then. If you have amendments that you're considering, I encourage you to go now and get amendments with fair warning that, we're going to have to turn it around relatively quickly.
Okay.
Hold on one second. I see Delegate Tolson, Delegate Kaufman. Delegate Tolson.
I just wanted to add, I was conferring with Delegate Carton in the banking with Wells Fargo. Can't remember the bank. Thank you, Delegate Carton. Wells Fargo is a situation that happened where it was Attorney General lawsuit. Okay, well, you may know, but I didn't know it was a lawsuit.
I wouldn't be, I don't know for sure, but I wouldn't be surprised, Mr. Chair, if because the Attorney General did in fact instigate the investigation or assisted in the investigation, right? This was federal.
It was a federal investigation with Wells Fargo.
But I think that the Attorneys General from across the country were part of the
lumped, kind of a joint lawsuit.
The lawsuit and then settlement, and then they were reimbursed through the funds that came through. In addition to the people that were wronged.
And Mr. Chair, I was just going to add that I do know that in the budget, the Attorney General had requested some additional staff. Obviously, we know the budget constraints we have, but there is, I think he was able, not an appropriations person, obviously I'm here, but I do believe there was some additional manpower given to that office. But you obviously want to confirm that with anyone on the Probst or Chair Barnes, but I believe that they were given some additional manpower to be able to deal with, doing some more prosecutions and being able to fully staff what the vision of the new Attorney General is. I just want to say.
So, such as it was, there was a hold used by Delegate Schmidt with regard to the odor bill, but Delegate Valentine, somebody else, or would you like to take a day to take a look at this and go from there? I'm willing. Look, I'm just gonna. I'll do it myself. It's fine. I'd like us to feel comfortable where we are. There are going to be people who are not voting for this. That's fine. But the question that was raised is real, and I want to make sure that we're all good with it before we go forward here. So that's fine. We'll take it up. But Delegate Kaufman, and then we're going to be moving on.
Yes, you're just a very generous man. I would not. I was going to, it's a done deal now, but I was going to argue against the hold because I think, we heard this a while ago. I think they said they only need 2 FTEs. I think we know how the vote's going to go. So, but you're very generous, and that's why you're chair. But
I don't know about that, but okay, fine. I would say, well, okay. I think that this is the right way to proceed. We can take this up tomorrow right after session. So we'll do that. All right. Yes, Delegate Valentine.
New precedents, or in fact, this has been something that's all I wanted.
And the fact, right this second, look, the Hannibal's here from the Attorney General's office, but we don't let people come up to the table and kind of intervene in the middle of it. And with no disrespect, it's fine. He was trying to be helpful. I think what's better, I think that's a legitimate question. Let's get the answer to the question and let's deal with that. And then we can go from there, and that'll be fine. Okay, with that. Hello, Delegate Ember, yes.
Just on this question, and I have no objection to the hold, but the Consumer Protection Division in the Attorney General's office does allow for recovery of costs. So there is some precedent, so it might be worth looking at that, if that gives you any comfort.
Okay. We will come back tomorrow after session and take this up again. And where we are on it is, and I will say, I think we did adopt the amendments. We were on the motion for a favorable. If anyone here is going to bring an amendment, we can talk about how that would work, but we'll go from there. With that, that concludes the voting session for today here in the House Judiciary Committee. We will be back tomorrow immediately after session, and we will have a voting session also, well, a lot next week. Thank you all very much.